What's up, everybody? Welcome back into another episode. We've got power, we've got internet. The AC is barely working in my office. It was broken earlier, but we're here and we're talking Richard Allen. A jury has been picked. 12 jurors and 4 alternates, I believe. 16 jurors picked in about a day and a half, which is pretty fast. And we're going to talk about whether or not we feel like there's anything nefarious going on. We're going to talk about the people who are there and who we can follow in this case, and who we can trust as far as information getting out of the courtroom. We'll talk about what we know. We'll talk about what we don't know. Some new information was dropped, but overall, we're going to focus on this jury selection process and how in the world it went this quickly. So make sure you guys hit the like button and subscribe if you haven't already. I forgot to start with that off the top. But picking a jury is a process that, from my perspective as a trial lawyer, is the most important part of a trial. Who your jurors are is the most important part of the trial. The lawyers know each other, the judges know the lawyers, and they all know each other. We know what witnesses are going to say most of the time and who's going to present a certain way. We know the facts of the case, but we don't know. Isn't that a crazy thing? Lawyers who prep these cases for years, you do not know who's going to be the decision maker in your case until the trial starts. So you can't really cater your case to specific jurors for those years leading up to it. And that's why it truly is you don't know what you're going to get and you don't know how this is going to end up process. But the process of jury selection is so important because once you know who your jurors are, you get a lot of information about them. And then you can cater certain aspects of the case to the jurors. What do they like? What do they not like? What are their backgrounds? What do they know? What do they not know about the case? And you've really got to vet these jurors. You've really got to understand these jurors in order to know what's going to piss them off, what's going to make them happy, what's going to make them sad, what might be an argument that strikes a chord with them, because you got to be careful. And you don't actually get to pick your jurors, right? You get to eliminate the jurors you don't want. And we had 14 jurors picked in this case out of the 16 after one day. Now, the judge did push the schedule. I heard there was only a 10-minute break, no lunch break. And just so you know where I'm getting some of this information, I wanted to give a shout right off the top. There are a bunch of people there. And, some of the bigger channels like Law and Crime and Court TV are out there. If you want to follow some of the reports that their people are putting out, that's always great. Andrea Burkhart is somebody I really trust. We're going to listen to a little snippet of her video from yesterday. She is there. She's a criminal defense attorney, and she is, doing videos every night. I encourage you to follow her. Defense Diaries and Lawyer Lee are also two lawyers that you guys told me are out there. I know Defense Diaries is obviously a criminal defense attorney. I don't know if Lawyer Lee is a defense attorney, but she is a lawyer. And they are all there for the most part, from what I've heard, because of all of the kind of shenanigans that have been going on in this case with the judge, with the lawyers, with the defendant, with the reports. And they wanted to make sure this is a fair process because we don't have cameras. And we've been so accustomed to having cameras in courtrooms, especially in big cases and big trials. And from my perspective, that's a great thing. And you have people now that are used to breaking down cases and discussing cases and reacting to cases and explaining cases, boots on the ground in the courtroom to explain it. That helps with the transparency that's lacking in this case because there's no cameras. Now, every case is not right for cameras. I believe the jurors are going to be sequestered in this case. So the judge is doing everything she can to make sure that there's no outside influences in this case. And that's commendable. Now, is everything commendable that this judge has done? Not necessarily. And we've definitely disagreed with some of what the judge has done in this case. But we're giving everyone the benefit of the doubt. We're hoping Richard Allen gets a fair trial. The biggest problem now is so much has been excluded that can he really get a fair trial? That's one of the big questions. And when I first heard that they had picked 14 jurors in one day and they were done with 16 jurors, a day and a half into it, in a high profile case like this, it didn't seem right to me. It just didn't seem right. In a normal run-of-the-mill car accident trial or truck accident trial or wrongful death trial that I'm picking the jury in myself with clients nobody knows, a case, basically my firm and my client's family are the only ones that care about it. It takes a full day to pick a jury of 6 jurors in a civil case with 2 or 3 alternates. A case that's going to last 1 week, and the jurors are not going to have to be sequestered, and they're not going to have to worry about any cameras. Many times they take a full day. Max, we get opening statements done for an hour at the end of the day, or we just start day 2 with opening statements. And what's the reason for that? You have to make sure that the only people that are getting on that jury are fair and impartial jurors. And the difficult part with that is jurors don't want to open up. They don't want to tell you about themselves. Jury selection is about having a conversation, building a rapport as a lawyer. You can't pre-try the case, which means you can't tell them all the facts of the case. In most cases, that's where this case is a little different. But it can take time. And one of the longest jury selections I had, so criminal cases are a little bit different, harder for defense attorneys, easier for prosecutors. When I picked juries as a prosecutor, it seemed easy to me. Everybody seems like they're on your side and with you. As a criminal defense attorney, it's very hard. And I'll tell you about one of the longest jury selections I had. Civil cases can be difficult because people are thinking, oh, ambulance chaser, billboard lawyer, just after money. It's probably a fake accident, or somebody did this or somebody did that. And you have to parse it down and say, okay, what would you need then to make it think it's not fake? Totaled cars, airbags, surgeries, whatever it may be. And I like to do that. I like to get into that with jurors, because the ones that think a lot of cases are fraudulent, when they see the pictures of the accident I'm talking about, they're not going to think it's fraudulent, right? When they see the injuries, they're going to know it's not fraudulent. Now, if you have a bad case, that might scare you. But as a criminal defense attorney, everybody hates criminals, right? And most of the people looking there at the defendant think they're a criminal. And it's very difficult. And it's a long process of trying to vet what people are actually thinking and actually believing. And I personally think that YouTube has helped me with that, and listening to you guys and seeing some of the direct and quick reactions you have to certain things, how hard it is to come off biases or where we start at. And I'm not accusing anybody of anything. It's just the truth. And we're learning together. And that's what I always say about me learning as we do this as a channel. So my dad and I had a federal case, and we picked a jury. My dad did the questioning. They don't always let you do questioning, but we ended up having to go, because it did have a lot of media attention in Tampa. And we ended up having to go days individually voir direing jurors and questioning jurors. And because of the newspaper articles, this was like when I first became a lawyer. It was mostly newspaper. It wasn't even social media. It was very difficult, if anybody had heard about the case or the facts surrounding it, for them to not automatically think he was guilty. So that's why I'm surprised that in a case that's been around as long as this case, I think it's like 7 years, with this much media attention, that they were able to pick a jury that fast. And immediately, I'll admit it, my head went to something nefarious is going on. But I can't watch. I'm not there. So that's why it's so great to have people who are there. And I saw multiple reports about how the defense was absolutely getting to ask the questions, make the arguments, take the stances that they wanted to take for the most part. Of course, they're going to lose objections, or the state's going to win objections. That's not what I mean. It's not like they're able to do whatever they want. But they were able to ask their questions, dig in, go up to sidebar. Now, even the lawyers there didn't know what was said at sidebar, but it seemed like all the arguments for cause and preemptory challenges were made at sidebar. And just to give you the quick and dirty about what that is, a cause challenge is this juror cannot be fair and impartial. They are not right for this jury, or there's some kind of hardship. They can't miss work. They have a surgery. They have a prepaid vacation. They don't speak the language. They have a hearing issue, sight issue, whatever it may be. Or they just tell you they can't sit on this case. Or if it's dealing with kids, they just can't be fair and impartial. Or they automatically think somebody is guilty. Or they have seen something about this case and they've already made up their mind. Those would be cause challenges that everybody should agree with, but sometimes lawyers still have to argue it should be a cause challenge. It's ultimately up to the the judge. Ultimately up to the judge. I'm reading comments at the same time. So from my perspective, it seems like all that was done at the bench. Don't necessarily know how many preemptory challenges were used. I believe the normal there in this type of case is 10 preemptory challenges and then 2 for the alternates. So I knew today was going to go quick because they only had 2 strikes each for preemptory strikes. But think about 10 strikes. So you go cause challenge, you could talk to all these jurors. And if there's only 50 jurors and each side could strike 10 to 12 people. That's 24 of them right there. So that only leaves 26 out of the 50 left. And you know people are going to have hardships and not going to want to be sequestered and away from their families and everything for so long. So how the heck did they find 14 out of, or I should say, 14 out of the 26 that were left over? That's wild. Most of our panels, just again, for a 6-person jury on a civil case, we get anywhere from 30 to 50 jurors that we get to pick from. And there have been multiple cases where we've gone through all 30 and we've had to keep looking. We've mistried a case because we couldn't find one in the 35 or 40 jurors that were picked. And there wasn't another panel the next day. That stuff happens when we pick trials because jury selection can be very difficult. I see everybody in the chat saying Lawyer Lee and Defense Diaries and Andrea Burkhart are there. Yes. And I mentioned that off the top. And yes, it's great to have real lawyers there and hearing from them. So I encourage everybody to follow them. Okay. So I said most of the time in jury selection, you're not allowed to tell the jury what your case is about. And sometimes jurors get really frustrated with that. And they say something like, tell us about your case. Why can't we know? We think you're hiding something from us. I've had jurors say that to me before. And I'm like, I wish I could tell you, but generally speaking, it's a car accident case. This person's suing this person for damages they say they caused. They say they're not at fault. They say they are. And that's kind of all we can really say. We can't get into how the accident happened, where it happened, what the treatment is, what caused the injury. Can't get into that, or what caused the death, or when the death was, or whatever it is. We can't get into that. We can't tell them how much money we're going to be asking for. But in this case, the defense requested and the judge allowed mini openings. So not full opening statements, but mini opening statements where the lawyers could tell the jurors what the case was about from their perspective. And the reason this is usually not allowed is because you don't want to color a jury's thoughts before they even start. You don't want to say, we think this guy did it and we have this evidence against him. And you'll hear about these mini openings. And most of the time it's not allowed. It's not appropriate. And I kind of agree with that. Sometimes I wish I could tell them more about the case, but I get it. Let it come out at the evidence. Let it come out at the right time. That's not really what jury selection is about. But in certain circumstances, and like this one, the judge allowed it probably to jog somebody's memory. Oh yeah, I do know about that case. I didn't recognize the name Richard Allen, but now that we're talking about Delphi, now I recognize the case. Now that I hear these facts, I recognize the case. Or now that I hear these facts, I can't be on it because of X, Y, and Z. So sometimes that can be really important. And that's why I just wanted to play a little clip here of Andrea explaining what those mini openings were based on her notes. It's just about 5 minutes of what each side kind of said in the mini opening. And I want to know, what do you think? How would this have kind of swayed you right off the jump if you're not even on this jury and you're starting to hear kind of arguments about this case?
Statement was that the case is about bridge guy, a bullet, and the brutal murder of 3 girls.
By the way, Andrea Burkhart, definitely going to get her on. I see other people asking for Lawyer Lee and Defense Diaries. I'll try to get them on. I've never spoken to them. I don't have any kind of a relationship with them. Andrea and I have messaged back and forth before. We've talked about some things, made some connections with different people for each other. So it's cool. She's really cool. Really, really smart. And I've already talked to her about having her on. I don't know exactly when we're going to make it happen, but going to have her on to talk about this case. Absolutely. So don't worry about that. But let's just hear her kind of explain bridge guy, the bullet. What are the connections? How are they going to get Richard Allen from her perspective?
That seems to me to confirm that this case is kind of as weak as I had thought. The bullet is really the centerpiece, and they're bolstering the bullet with the statements that Mr. Allen ultimately made implicating himself. So
they mention a confession. So the state mentions a confession in jury selection. People, think about this, right? It's hard for us to separate ourselves because those of us that already know about the confession, right? We're like, yeah, we already know. We know the arguments the defense is going to make against it. We know. But if you're just sitting here and you're a juror and you really don't know anything about this case, which from reports from many people in the courtroom and that were watching this jury selection, a bunch of people did not know about this case that were potentially going to be picked for this jury. So a bunch of them didn't know about this case. So the first thing you hear is bridge guy bullet and he confessed. What are you thinking? What are you thinking? Yeah, I see people talking about the issues with the bullet, issues with the confession. Sure, all that is fine and dandy. We're going to talk about that as the trial goes on. But my perspective really is, if I'm sitting there and I'm on a jury and I don't know anything about this case and I hear a guy confessed, I'm a lawyer. I understand false confessions. I've argued them before. But what do you think your average juror is sitting there? I would think I would start to be like, whoa, what are we doing here? Right? So I feel like some of the jurors were, and it sounds like the defense lawyers did dive into that and ask some questions, and we'll talk more about it during their opening, but that's pretty bad for a defendant if in jury selection, the state can stand up there and say he confessed. And we talked about that from the jump. Even if you have good arguments against a false confession, it's very difficult to win a case when you have a confession.
Mr. McClelland described the case that these girls lived in Delphi. They were off school on February the 13th of 2017. It was an unseasonably warm day, so they decided to go out to the Monon High Bridge Trail, which crosses about 60 feet over Deer Creek. It is high. It is a high bridge. You can't. They have it blocked off now, so that, I mean, you could hop the little rail fence that they have if you wanted to, but I sure is not going to. God, this place is like scary enough, even without having to kind of navigate something like that. But seeing it, as a lawyer, it's one of these things that just kind of shocks me that people were ever allowed out there on the first place. I mean, it's a railroad bridge. Like you have the ties, and 6 inches between each one. And that's what people are walking on, all the way across, like 60 feet over the water. There's no rail, nothing. Like, if you're not into heights, I'm really not into heights. I was not going to look forward to walking across that thing. So he points out, kids like to cross it. It's kind of a test of their bravery, or maybe it's just fun or something like that. And so Abby and Libby decided to do it that day, but they were not alone. They were followed by a bridge guy. A bridge guy used a gun to kidnap them. He forced them down the hill. According to Mr. McClelland, his intent was to have his way with them, but he was interrupted. So he forced them to cross the river, remove their clothes, and then he cut their throats. According to Mr. McClelland, he then threw the clothes in the creek, went back to his car, but he left behind a clue, this bullet. The bullet was right between the bodies, and the markings show it was cycled through his gun.
So again, we'll talk about dealing with it, and people are saying Runkle would come on for that. That'd be awesome. I'll hit him up if you guys want me to continue covering this case. I know there's no cameras. I know other lawyers are there. If you want us to focus on something else, we're definitely covering Sarah Boone, but I was planning on doing every couple days or maybe once a week on this case. If you guys want that, hit the like button. Let me know in the comments. Don't have to if you guys aren't interested in it. It interests me, just especially because of everything that's happened pre-trial. But regardless of the pseudoscience, regardless of how bad and not reliable this bullet may be, if you're hearing about this right now as a potential juror, he left a bullet behind. It cycled through his gun. He confessed to it. Yes, I am Dave. They would have heard in openings, but they're jurors at that point. You get to know a lot of information about them at that point. But now that they know this, how is it going to affect their answers? Are they going to want to get on this jury to make sure there's justice for these victims and get that guy who confessed and left his bullet behind and wanted to have his way with these girls? It just opens up a lot of questions that usually don't come about in jury selection when you're able to give many openings and drop these kind of facts that may have issues with them, but at this point they sound like facts.
And from Mr. McClelland, we heard that we will...
McClelland, she kind of says it both ways. I don't know how to say it, so I'm going off of her pronunciation, is the prosecutor.
Learn from Mr. Allen's own words that he was there at the time. And we'll hear on the video, according to Mr. McClelland, that Mr. Allen is bridge guy. And of course, we'll hear from Mr. Allen that he told his wife, his mother, his therapist, his corrections officers, fellow inmates, that he brutally murdered them, and that he will say why and how, and he will repeat it over and over again. So that was the mini statement that we got from Mr. McClelland.
So people are asking if this is her mini opening. No, the actual lawyers, the prosecutor and defense lawyers, gave mini openings in voir dire. The judge reads the charges, tells what the case is about, and then the lawyers were able to kind of lay their map of where they think the case is going to go. So not make arguments, but an opening statement and tell the path of what they expect the evidence to show. It's very interesting. And even with this, to have this quick of a voir dire, again, I'm confident because I heard from multiple different reports that the defense lawyers were able to ask certain questions that judges sometimes would cut them off. And in this case, the judge didn't necessarily cut them off. I'm going to talk about that after we get through the mini openings, but I'm encouraged from what I'm hearing is what's going on in the courtroom than maybe what I would have expected based on what happened pre-trial. So now we get to the defense's mini opening.
Mr. Baldwin gave the mini opening statement for the defense. And Mr. Baldwin started by saying, Mr. Allen confessed to taking the gun and shooting the girls in the back, but the girls weren't shot. And so he pointed out repeatedly that Mr. Allen admitted facts that were not true. That was really the focus of his opening. He said that Mr. Allen confessed to raping the girls. I'm probably not supposed to say that on YouTube, but oh well. And burying them in a shallow grave. But neither of those things had happened as well. There was no evidence supporting them. So
people are saying she said 3 girls. It was a long day, I guess. And it's 2. Very clear 2. Yeah. So Sleuthy, I did listen to her say coke deal hair. My guess is that this is also an example because she said longer slick back hair. So my guess is I might have coke dealer hair too. Never tried it, never dealt it, but if that's the kind of hair I have, that's the kind of hair I have. So it is also important though that the defense was able to respond. Obviously, they were able to talk about why that confession might have problems, right? And so that's going to give the jury kind of 2 things to think about. I just think most people generally take confessions at face value. And some people are saying that doesn't sound like a lot of evidence that, that the state has. Well, I agree with you. I think there's some holes in their evidence, but I think there's a lot we don't know because of the gag order and all of that. And there's a lot we're still not going to know probably because no cameras in the courtroom. But even if you don't have a ton of evidence, a confession is a huge piece of evidence. And the defense, even though they don't have a burden and they're never supposed to have a burden, absolutely has the burden to prove that is a false confession now. Once there is a confession, that's why you want the judge to throw it out. That's your better argument. If you have a legal argument for the judge to throw it out, because once there's a confession, it's so hard to get over it.
So ultimately, the problem here is that Mr. Allen confessed to a crime he didn't commit and relied on facts that were not true.
And it is a good argument about a false confession. The jail stuff, facts that aren't true, telling everybody stuff, just kind of losing it a little bit and just admitting to it because of the condition he was under and the situation he was in.
He argues that tons of admissions and confessions are not true. And the context is what was going to be important. Mr. Allen had languished and deteriorated in solitary confinement in Westville Correctional Facility, a prison where the worst of the worst are held. The day before this happened, he was at home with his wife of 30 years and his dog when he was arrested for a crime he didn't commit. And then 15 days before an election, the sheriff sent him to the worst prison in the state and in the worst part of that prison, the solitary confinement. Mr. Baldwin told us we were going to see video of his life in there. This took me back to James, can't remember, Joey. He had pursued an insanity defense, and some of that was based on James Holmes. Thank you, K. Elf. Thank you, James Holmes. The defense had raised that in part based on video surveillance of his setting. Very similar situation. He was held in solitary confinement for an extended length of time and basically, went nuts. And you can see it. You can see what he's doing in the cell. He's banging his head against the wall, hiding under his covers for 20 hours a day. I mean, just a lot of stuff like that. So I'm expecting this video is not going to be real pleasant. According to Mr. Baldwin, psychologists will tell us that these are the ingredients for a false confession.
They even get into what their experts are going to say in this mini opening statement. It seems like it just had the same rules as an opening statement. And just to give you a comparison, like a lot of times if we're doing jury selection, we can use hypotheticals, right? Like let's assume this happened. How would you feel? Right? Let's assume somebody wasn't wearing a seatbelt. How would you feel? If somebody was speeding, how would you feel? How do you apportion fault? Depending on what the damages are, could you give $10 million? Do you think there should be a cap on damages depending on what the facts are? Well, if they broke their arm, maybe it should be this. And back and forth, kind of just talking about hypotheticals. That's usually what can happen more in jury selection rather than something like this, because an objection in jury selection is that the lawyer is pre-trying the case. And usually that's an objection that will get sustained. But that's exactly kind of what they were trying to do, or what they were allowed to do here. I find that very fascinating. This whole mini opening concept. I've never done it before in jury selection,
which is consistent with everything that I know about that situation as well. He talked about soft evidence versus hard evidence, and pointed specifically to the bullet. He said that Melissa Oberg is the analyst who has done over 1,100 comparisons, and according to her, she has never been wrong, but she has found fault with others that she has supervised. They've been wrong, but she has not. So Mr. Baldwin was apparently pitching this as kind of soft science, something that's subjective and not necessarily falsifiable or verifiable. He points instead for his example of hard data to the phone. He says there is hard data in the phone. Where were the girls? What were they doing? The state police, again, just flashes to these other cases. There's echoes of Koberger in this. The state police were ill-equipped to understand the phone data, and there was infighting between the FBI and the local police. The local police apparently didn't like the FBI's interpretation of the phone data, and so they just cut them out, just dismissed them. Mr. Baldwin concluded by telling us that Mr. Allen is innocent, and the evidence is going to show that.
So that is the mini openings there, back and forth, issues with experts, issues with the bullet, phone data, false confession. So wait until we get to put on our case, basically. It may not seem so cut and dry. And she also brought up a good example. They brought like, I'm a lawyer. You guys know I'm a lawyer beyond a reasonable doubt. And then defense got up and said, there was a guy that practiced law in a courtroom just like this, wasn't really a lawyer. So that's why you got to wait and find out the whole truth. So make sure you guys follow Andrea if you're going to follow this case. Andrea Burkhart, that was her YouTube channel. If you guys want to back it up, you can see it. And if you come from here and you're brand new to Andrea, just let her know we sent you over there. Hit like, do all the stuff, subscribe to her channel. She's awesome. And we will absolutely have her on here to talk about this case at some point. We've already started setting that up. Coffee Mom said, it's funny you're wanting AC. We have our heat on. Oh, I wish. It's supposed to be a cold front coming through for my birthday, actually. It's October 16th, where Azam is. Thank you, Azam. Not quite October 16th yet here. Rebecca said, can we follow the Leilani Simon trial? Rebecca, it's very interesting that you were to bring this up today, because before today, my answer probably would have been no, I don't think I can follow 3 trials at once. It's hard enough trying to follow 2, but we have a very special guest coming on this week's podcast Monday, and we're going to be talking about 2 cases, and Leilani Simon may just be one of those 2 cases. Andrea said, hey, Peter, they seem to be having problems selecting a jury for Sarah Boone. I mean, when you have these high-profile cases, I would expect it to be difficult. I'm going to do a video tomorrow probably breaking down where they're at in the Sarah Boone jury selection, so I'll hold on this. But that doesn't really surprise me if it's difficult to pick a jury in these kinds of cases. Rebecca said, Peter, can there be an appellate issue about how the jury was picked, leading the jury during jury selection? So potentially, but not if the defense isn't objecting. If Andrea is sitting there and Lawyer Lee and defense diaries and all those lawyers are sitting there, they're not saying the defense is screaming about how unfair this is and the judge is pushing them. Now, they could be making objections on the record at sidebar, which we would not hear and the lawyers would not hear. But if the defense isn't saying this is a big problem, it's going way too fast, this is unfair, we're objecting, putting it on the record, I wouldn't expect it to be an appellate issue. And let's get into that a little bit about what we can learn about the objections and the rulings made by the judge on whether or not this has been a fair trial and a fair jury selection with how quickly it's gone. First off, I'll say the lawyers seem to think it is. And here are some indications. The defense lawyers are able to give an opening statement. The defense lawyers are asking questions like, is it possible that Richard Allen is innocent? Which is always an objectionable question. Now, I think there are some legitimate reasons you should be able to ask it, but a lot of lawyers on the other side, a lot of state attorneys will object to that question, and a lot of judges will sustain it. That's what happened here. But why is that an indication to me that this is a fair process? Well, I will tell you. I have, and other lawyers have, my dad a lot, have been cut off by judges in jury selections when we ask certain questions. Mr. Tragos, don't go down that road. Mr. Tragos, don't try to condition the jury. Don't try to pre-try the case. Mr. Tragos, I'll explain to them the law. If sometimes we're trying to explain to them, this is what reasonable doubt is, or this is what witness credibility is, the judge will say, I will instruct the jury on the law, Mr. Tragos. That's not the time for that, whatever. And a judge will step in and cut off an attorney usually a defense attorney or a civil plaintiff's attorney. Well, that didn't happen for a lot of these questions. And a lot of them that are kind of obviously objectionable, that buzzwords, when you say certain things, we do this enough to where we know certain arguments certain lawyers make. And when they say it, we're ready. We object, right? And whenever we start talking about damages and what's too much and would you put a cap, the defense lawyers are there ready to object. When I get into those, I have to be careful about how I ask it appropriately, because there are very appropriate things. Because if you think there's a cap on damages in a state like Florida who doesn't have a cap on the damages we're discussing, and a juror would arbitrarily put a cap at $1 million or $10 million or whatever, that's objectionable. I'm going to argue that juror should be struck for cause. But the judge allowing the other lawyer to object, or in this case, the state to object to that defense's question, lets me know the judge isn't cutting them off. The judge isn't just putting them in a box and not allowing them to do their job. It sounds like, from all reports, that the judge is allowing the defense to ask their questions, to dig in, to say, look into your heart, to bring emotion to the table, to say, wait until we present things, to give counter hypotheticals to what the state is discussing and the questions the state is asking. And that's all really important. And to me, that's indicative of a fair jury selection process. And maybe it's just going quicker than expected, and maybe nobody there, because I know that it's in a county where they said this was not as big of a story as other counties in Indiana. And maybe people just really don't know about this case. Maybe it's too old. Maybe they don't remember. But it is so surprising to me. That's not hyperbole. That's not blowing smoke. I was shocked when they picked 14 jurors out of 50 the first day. I don't think I'd ever be able to do that in a trial. Pick 14 jurors out of 50 in one day. Even a normal trial. We got to dig in. We got to do our research. We got to find out as much as we can about these jurors. Now, I don't know what the rules are. Some courts don't allow you to do any research into the juror's background. I hate that. I don't know why. I don't think you should invade their privacy, obviously, but their public forums like social media and stuff, I think should be fair game to look at, to make sure everything's appropriate. If we can find out anything that is public record, make sure they're telling the truth. We've seen that issue come up in cases post-verdict, and we want justice. We're big fans of justice. So I don't understand why that wouldn't be allowed or appropriate. So an indication, so that's some good indications, right, about how this is going. Well, here's kind of a negative. But Peter, should emotion not play a part? So no, not to be emotional about it, right? But some lawyers like to bring it into it, and they like to ask for sympathy even though you're not supposed to. But I think what he's saying is, don't just give a quick judgment. Think about it. Ponder on it in your soul. Do you actually think you could sit there and say he's innocent or say he's not guilty if the state doesn't reach the highest burden in the land of beyond a reasonable doubt? That is the highest burden. Civil court here, family court here, all lower than beyond a reasonable doubt. Think about it in your heart. Do you really think you could hold him to that burden? It's not just maybe. It's not just probably guilty. So I would assume that's more along the lines of how he was doing it. So while those are indications that things are going well, there's an indication that happened this morning to me that is problematic with picking jurors this quickly. And it's problematic when we have a situation where maybe we're not giving enough credence to certain hardships in order to make sure we get a jury quickly. Kit Hanley said 3 jurors have been bounced. So we picked 14 the first day. Right at the beginning of day 2, which was today, 3 jurors were bounced. The number of jurors is now at 11. And the 3 jurors that were bounced, a mom with childcare issues, a professor with diabetes issues, and then we don't know about the third one. So just so you know, they went throughout the day and they ended up filling all 16 and they picked the rest. So the jury is picked at this point. But I don't think opening statements are till Friday. I think they've got some motion hearings and things like that. So immediately, one day into this process, that's going to be weeks and weeks long, 3 jurors are already out. Now, there's 2 explanations for this. Number one, they were borderline, and because it went so quickly, the lawyers went up and were like, Judge, maybe we should think twice about this. We've got all 50 more jurors. We were able to pick 14 out of that one. I think we'll be able to get 5 out of this one. Let's send those 3 jurors home in an abundance of caution. And if that's the case, kudos. And they did the right thing. And let's just make sure we get a jury that can sit through this trial. The other option is they were like, oof, they're not going to be able to sit through this trial, Judge. What are we doing? Because they knew about this yesterday. I would assume. I should say I assume. Maybe they came back and they told them, oh, I thought I had childcare coverage. I don't. I thought I was okay. My doctor told me I wasn't. Right? That could be the case. And if that's the case, nothing nefarious going on. But the other option is they just moved too quickly. They didn't take the hardships seriously enough. Because if you got a mom with childcare issues, I get it, but you can't put them on this trial. You can't force them on this trial. They're going to be thinking about childcare. They're going to have a split memory. They're going to be trying to deal with all that stuff. They're not going to be focusing on this trial. Or a diabetes issue that could pop up and have him removed in the middle of the trial. Do we really want to take that chance? And I would say no for my trial. So a trial of this magnitude, I would definitely say no to that. So how did they get on the jury in the first place? One explanation is they were being pushed and we got to fill this jury. We got to fill this jury. Let's get butts and seats. Let's get this started. I don't love that. This is an indication that maybe they went a little too fast the first day. But I hope that all their jurors are okay. And also 4 alternates and 3 people are already gone. It scares me as well. So that was not a great indication. Let's take a look at some other tweets here. One by Andrea saying we've got 14 jurors, 3 were out. So they started the day with 11, 5 to select. They each had 2 strikes for the preemptory. So you have 10 to pick the first 12, 10 strikes each side for any non-discriminatory reason, and then 2 for each side to pick those 4 alternates. They can, if everybody agrees, you can pick more alternates. Usually you'll get more strikes if you're picking more alternates. But it seemed like everybody was fine with 4 alternates and 2 strikes each side. And then Defense Diaries gave us, I believe, a breakdown of the jury. And that's why it's so cool to have actual lawyers there, boots on the ground, just trying to focus, trying to pay attention to what's going on. 12 jurors and 4 alternates have been seated. 10 women, 6 men. What did you think? I should have asked you guys what you thought the breakdown would be and what you think would be better or worse for Richard Allen, but let me know. What do you think would be better age-wise? Because lawyers think about this. What's better, right? Do we want leaders who are managers at work and have really intense jobs? Do we want people that are detail-oriented? Do we want people that are more big picture? Do we want people that work out of the home or, stay at home or retired or unemployed people? Or do you want men, women, older, younger, middle-aged, whatever it may be? What do you guys think? If you're the defense team, what do you think you want as a jury? And I'll just tell you, it's a lot harder as a defense team to figure this out and pick this stuff. For prosecutor, it's a lot easier. Most jurors are good for you. I loved picking juries as a prosecutor. Felt like we were on the same team, So there's the breakdown. And then this new piece of evidence that I've heard some people mentioning, that's been mentioned, I guess, for the first time. B. Mata, I believe, is Defense Diaries. I think it's multiple people. I think his wife is also a lawyer, part of it. But so I guess he's breaking this news about, and other people have posted about it too, about this hair and how there was hair found in one of the victim's hands, doesn't match Richard Allen. Other reports that in the past they've discussed DNA and they had DNA evidence. And, is this not true? Do they actually not have DNA evidence? And is this proof that they do not actually have DNA evidence? All I will say is the trial like this, or like Kohberger, these trials, there's a lot we don't know. I am just going to wait. I don't know what this means. I don't know if it means somebody lied. I don't know if it means somebody embellished. I don't know what it means yet. They could have other DNA. They could be wrong. Could be like Murdaugh, where they did the splatter test and they thought it showed one thing, but then later it turned out it was wrong and it didn't show something. That happens sometimes. It could be corrupt. It could be much ado about nothing, aka a nothing burger. So I don't know yet, but it seems like it's not good for the state, right? Afton said, why did the state object to Baldwin touching Allen's shoulder? Why is that inappropriate? So I didn't hear this until right now, but Sometimes lawyers will object to using first names, for being too sympathetic, trying to garner sympathy, touching them on the shoulder, over personalizing them, right? Some defense lawyers love to over personalize, and plaintiffs' PI lawyers like to over personalize. They're not even over personalize, just personalize the defendant so they understand this is not just some horrible person the state and law enforcement want you to think it is. And sometimes they object, and it really depends on the judge. I don't think there's anything inappropriate about that at all. Azam said, is that common to have a mini opening? No, not common. I thought it's only asking the questions to choose the best jurors, or is it depends on the jurisdiction? Well, it depends on the jurisdiction of the judge. It's definitely not common in Florida, I'll say, where I've tried most of my cases. All of my cases to this point. Pesky Pirouette. If the sticks were arranged like runes, why can't defense discuss Odin Satanism? Won't they show the photos of the girls? Makes no sense to me. I agree. This makes no sense to me. It's a judge's decision. It's one of those decisions that's going to have a huge, profound effect on this trial. I don't understand why, if there is evidence to corroborate it and it's a reasonable inference from the evidence, I don't understand why they wouldn't be able to argue that as a defense. Third-party culprit type stuff. Police screwing up the investigation. A reasonable doubt. I can't fathom it. I honestly can't fathom it. Rebecca said, after a jury is seated, can they go back and pick more? Especially if they lost alternates. No. So they can't, once jeopardy attaches, that's the jury. The jury is sworn in. You cannot add any jurors there, especially once the trial started. They've missed part of the trial. That's why maybe for a case like this, pick 8 alternates or 6 alternates, right? You get more. Usually, in my case, we do 6 and 2, and that's for like a week trial. So 12 and 4 for a multi-week trial like this, lots of issues. You know, if I was the defense, actually, so here's a little behind the curtain. If I was the state, I would argue for more alternates. But the defense sometimes doesn't mind a mistrial. Sometimes a mistrial can be a win. Sometimes they file lesser charges. Sometimes they alter the charges. Sometimes they make you an offer. Sometimes they drop the charges after a mistrial. I don't think that's going to happen in this case, but sometimes a mistrial can be a good thing. So maybe the defense doesn't want more alternates. I don't know. Rebecca said, Peter, I would like to hear your take on the opening from the state on the Simone trial. So I'm not going to be able to watch the trial gavel to gavel. I'm just not going to be able to because I'm following Delphi and Boone literally at the same time. But I will give some thoughts and answer some questions that people have on that trial. I'll follow some recaps of it, but I'm not going to be able to fully dive in and watch every second of it. Sleuthy, they're putting $4 million into this trial. Mistrial will bankrupt the county. Nobody wants to do this crap again. Well, again, that's the truth. And maybe there's not enough money and the mistrial happens and the public is in uproar. Maybe that's something that's good for the defense. And maybe that's why they're not pushing for more alternates. I don't know. I'm just giving you all of the discussions that could potentially be happening in the background and all of the different things lawyers think about, right? Also, if a mistrial, maybe you get a new judge. Maybe you're able to make those Odin arguments. I don't know. Things can change on a mistrial. It all depends on how you feel your leverage or strength is at this point in time. Let me think if there's anything else. So yes, motions in limine are going to happen, I think tomorrow, but there are issues with the sketches. I guess the state wants to limine out the sketches, which I find to be very interesting. Why does the state want to limine out the sketches? I don't really know. But we'll see. We'll see what else is subject to the motion to limine. The more important thing is going to be, we just want the judge's answers, right? What's going to happen? What's coming in? What's coming out? Trial's about to start. Now is the time where we start getting the truth. We start getting the real evidence. We start seeing if there is enough to convict Richard Allen beyond a reasonable doubt. And from my perspective, jury selection is the most important part of that. The most important part of the trial. You have to find people that are open-minded, that are willing to come in, sit down, look at everything, and make a decision based off what they just see and hear in this courtroom. Not what they've heard, not what they've read, not what they've thought about before, not something that's happened in their life, not a cop that they know and base all their decisions based on that cop, not a lawyer they know, not a defendant they know, not somebody's sister's cousin's uncle, but coming in and being open-minded and just waiting to hear what's presented and making the decision based off that. Sleuthy said, news just reported another seated juror has been dismissed. Yeesh. It's not good. It's not good. Bodie, Peter, are there more convictions with just 6 jurors? So that's a great question. And I think that I would say, and this would be just kind of a guess, I think I would say no. The reason for that is capital cases, 12 jurors, more serious, and I'll just say Florida, right? I'm just talking Florida. The conviction rate is higher, in my opinion, in those cases than it is on certain misdemeanor trials that maybe jurors don't take as seriously. I mean, possession of marijuana cases in Florida back in the day when they used to actually prosecute those, they would lose all the time. And that was only, and I say prosecutors would lose all the time. So more not guilty verdicts. Lesser crimes, in my opinion, have more not guilty verdicts than serious crimes. And a lot of cases go to trial because the offer is life or death penalty or death penalty. We're not given any deals. So we're going to trial. And if it's death penalty case, it's 12 jurors. And from that perspective, I don't think the conviction rate goes down. But I get what you're saying. It'd be harder to convince 12 people unanimously than 6, but the nature of the case sometimes helps with that, in Florida at least. Yeah, there's going to be all sorts of testing and experts, DNA, ballistics, cell phone data, all sorts of stuff. But I just really hope they're not rushing through this jury selection. I mean, openings aren't until Friday. I get it that you have motions in limine to deal with. That might be a day and a half, but we still got more time today, maybe at least another half day or full day, and should be able to take our time with it and make sure we get a jury that's going to be there and that's not going to be dismissed. Right now, they could agree to more alternates. Before the jury is sworn in and it's all done, it's unusual. Usually at a pretrial conference, you write down how many jurors, how many alternates, how many strikes. Do we agree on this? Do we want to argue about that? Does one side want more time or the other? How much time do you need for voir dire? How much time do you need for opening statements? We kind of agree on all that before trial. So they probably have all already agreed on 4. If they wanted more, now would kind of be the time to do this. All right. I think that's it. For the update. Make sure you're following the lawyers that are there. And go ahead and tag me on stuff and send me stuff on social media that's happening on this case. I'll try to be following along as much as I can. Hit that like button if you guys want me to follow it. And again, let me know in the comment section. Make sure you subscribe to our channel as well. We're going to be covering a couple cases now, a couple different trials going on. It's going to be a busy couple weeks. But I appreciate you guys so much for being here. I appreciate you helping me with jury selection. Rebecca said, I won't be able to make the foreman Zoom. So happy birthday, Peter. Hope you make it or have a wonderful day. Sending love from North Dakota, where it is freezing. It is so wild, isn't it? Isn't the world a wild place, right? I'm sweating. She's freezing. Same day, same time. Did I see the 2 motions limiting? I did not. I just saw the sketches is all I saw on one. I did not have time to break them down. But I'll try to potentially check them out if we do another video on this one this week. But all right, that's all we got. Till next time, folks, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.